Welcome to Infringe at Your Own Risk.
Hello and welcome back to Infringe at Your Own Risk with Rand Bateman. Rand is a registered patent attorney with decades of experience protecting patents, trademarks, and copyrights for clients from startups to international companies. I'm Kevin Rosenquist, and today we're talking about how to turn your intellectual property into income without giving up control. We'll unpack how licensing works, what to watch out for, and how to make sure your hard-earned ideas stay yours. Rand, welcome back.
Thank you, Kevin. Appreciate being back.
Absolutely. So let's start here. Could you explain what it actually means to license your intellectual property?
Yes. So when you're licensing something, you're giving somebody else the right to use it while you're maintaining ownership. So when you have a piece of intellectual property, you can sell it to somebody or you can give them the right to use it, often on a temporary basis. And then they pay you for that right. That can be really important because oftentimes people will invent something that they may not even have the ability to make the end product, but they know of somebody who has the ability to make it, wants to make it, and make profit from it, and then they receive some portion of that profit back as a licensing fee to the entity that's making it. So there's literally dozens of different ways you can do a license. I get calls all the time from clients. Can I license it like this? It's like the answer is usually yes. You just have to make sure that you set it up properly so there's control, so you retain the rights that you need and you aren't damaging your intellectual property in the process.
So it's almost like leasing your product in a way.
Mm-hmm. Yeah, it's leasing your intellectual property right.
Yeah.
You can use this for some period of time. You pay me a royalty, and then you'll benefit by selling products or services to other people. So
in what situations when clients come to you and they're not sure exactly what to do, like what kind of questions do you ask or what kind of advice do you give on whether an inventor might choose licensing instead of trying to make and sell the product themselves?
So an awful lot has to do with their model of how they want to benefit from their invention. Some people will say, I have an invention. It's relatively simple, but I just want money for it. And then we assign the patent to somebody who's interested in selling that invention, and then they get money. And that's typically done with an assignment. The other way is licensing. Okay, what are your goals? Well, I want to make sure I've got a long-term income stream. I don't want to get $3 million today. I'd rather get $100,000 a year for the rest of my life, or however it applies. And so the inventor has to decide, or the copyright holder or the trademark registrant has to decide, in what way do I want to commercialize this. A great example is Wilson, the sporting goods company. For many years, they made virtually no products.
Really?
Yeah. They just licensed the name. Other people made the products and then sold under their brand. And so you can do that. There's people who never make a product under, for example, a trademark that they own, but they license it to somebody. They, as part of that license, the benefit inures to them. So as the value of the trademark grows, the owner has an increasingly valuable asset, and they're getting paid from the owner, or for the person who's licensing the trademark for that period of time. So it can be a big win-win situation if somebody has a product. In intellectual property, licensing typically happens in one of two areas. Number one, I don't want to create the product itself. Mm-hmm. I don't have all of those facilities, whatever. An individual inventor may figure out a way of improving an existing product. Well, the company that makes the existing product may want to license from that inventor so they can make a better version of their product. Or a competitor, number two or number three or number four in the industry may say, this is my ability to jump ahead. If I make, let's say a digital camera and it has these additional benefits to it. I can move up in my rankings against my competitors, and so they'll license it and pay the person money. So that's one dynamic, is somebody licensing other companies. They don't want to make it at all. Another place that's common is a lot of times inventions will have applications in different industries. So if I'm in the medical products industry and I invent a new way of making a catheter, the way I extrude a catheter is a tube basically with several lumens in it that doctors can put tools in and out of your body and perform surgery, without having to cut you open like they used to. Well, that same technology that they use to make that catheter could be useful for making other sorts of tubes in different industries. And so a medical products company may say, I've got this great technology for making catheters, but it also applies to tubes used by companies that do inspections on equipment, right? So you can buy sometimes little cameras that you can snake into something, so you don't have to take the whole product apart. You can go in and look and say, oh, okay, I can see what the problem is. Before you disassemble anything, you know what problem you're dealing with. So the medical products company can license the person who makes those little cameras and say, hey, we've got this improved way of making this lumen that you're using, or the catheter you're using to go into this machine. We'll license you. And let's say, just for example, it just simply saves money, right? It's a way of making that tube with the lumen that's cheaper. Well, the company that makes the product that's not in the medical industry may say, hey, it's worth it to us to pay $1 per tube that we make, because we save $3. So we'll pay them a licensing fee to use their invention, and we'll save money and we can make it more efficient. Years ago, I had a medical products company I was doing work for, and we patented a whole bunch of technology around one of their core products. And all of this patent work was done because it saved them 1 nickel per product. Okay, 5 cents per product. But they sold so many hundreds of millions of this product that it became financially beneficial to them to patent it, so nobody else could adopt the same thing. Because if you've got a fungible product that you're competing with your competitors, that you can't exclude them from the market, if you can find a way of doing it less expensive or with higher quality, that becomes the value. And with licensing, if I've developed technology that I'm not using in your field, I may be happy to license you and have you pay me money because you're not competing with me. We do separate things, but I can make more money by exploiting those licenses. And there's companies that own, thousands of patents and license them. There's also the situation, what they call patent pools. You can't make a computer today without infringing somebody else's patent. There's just too many patents on there.
Yeah.
And so what industries will do is they will have what's called patent pools. So you come in and I want to make a computer. Well, I have to pay a royalty to everybody else. And often in some of those pools, the amount or the way the royalty is split up is based on how many patents a company has. So company A has 1,000 patents. Company B has 100 patents. Company B is going to pay a higher royalty rate to use everybody's patents than company A is. And company A may actually not pay anything. They may get things back from the licensing, just because everybody else has to license their patents in order to make a computer. So there's several different contexts in which licensing can be desirable. For most small inventors, when I work with small inventors, usually they're licensing it because they don't want to be in the business of going out, developing the product, producing the product, hiring a sales and marketing staff and doing all of that. They want to find somebody who will take their invention, run with it, and just pay them a licensing fee for the rights to do so.
I mean, that's like that passive income that a lot of people would love. I mean, I can definitely see the appeal of licensing over doing it yourself, unless you're someone who either wants to start a business, is eager to start their own business where they're actually producing a product, or they're already in that somehow they already have some other product they're producing that they can use the same facilities or whatnot. But I can definitely see how that would be an appealing angle. What types of IP can be licensed? Can any IP technically be licensed?
Absolutely. Yeah,
Okay.
any type of IP can be licensed, but there's different rules for each type of IP, right? For example, for a patent, you can license a patent, and you can license it in one of two general ways. You can give people what's called an exclusive license, right? So if I have that patent with respect to producing catheters, I can license one company so they have the exclusive rights. Now that's beneficial to them because if they have the exclusive rights, none of their competitors
Mm-hmm.
can make a competing product. So they either have a better product or they can sell it at a lesser price. It gives them a competitive advantage in the marketplace. The other type is a non-exclusive license. And sometimes if in order to compete in an industry, you have to have a license for something, right? I mean, if you're going to make cell phones today, it would be really hard to do without having a camera on the cell phone.
Yeah, I would say so.
Right? I mean, just everybody. I mean, when was the last time you picked up a digital camera that wasn't in your cell phone? It's just they've gotten so good. But if you want to sell a camera, or if you want to sell a cell phone, you've got to have the camera. Okay, so in order to have the camera, I have to license whoever's got the patents on the camera. And when it becomes you have to have, then the licensee, or I'm sorry, the licensor, the person who owns it, just can license everybody and say, you know what, if you're going to have a phone with a camera on it, I get 1%. And then everybody pays the 1%. And that's called a non-exclusive license. So anybody can use my patent, but if you're going to use it, you're going to give me 1% of your sales price, or however you want to figure out what the royalty is going to be. Mm-hmm. And those can be worth insane amounts of money.
I would say so, especially in your example.
And so if you've got a standard setting patent, if you've got something really unique, the non-exclusive license is great. If you have a product that makes it something a little bit better, often licensing exclusive is better, because why do I want to pay you a license to use your invention if everybody else is using it, if it's not a critical thing, right? If it's a nice option to have, but it's not, okay, I've really got to have this to be in the marketplace, the value goes down. And that's one of the really interesting concepts with a patent. When you get a patent, if there's two inventors, both of the inventors own the patent in total. So either one can go out and license whoever they want. Well, if I've got a patent for a tractor and I go and license John Deere, but my co-inventor go and licenses Massey Ferguson, that takes away the value to both those companies, because they're now just competing with each other again. Neither one has a unique thing that they're able to sell that gives them an increase in price. So
what typically, when you do an exclusive, is there a typical amount of time that they'll do that for? Because I imagine it's not just in perpetuity.
It depends. I mean, you can only license your intellectual property as long as it survives. Okay, so for a patent, a patent lasts 20 years from the filing date, typically. There are a few exceptions to that. But you can only license the patented subject matter during the life of the patent. And then once the patent expires, the license disappears and you go on. Other things you can license for much longer. Copyrights last much longer, so you can license that for years and years. And there is a right under Prior Copyright Act that you can, that the original owner can get back rights if they've licensed somebody. And then in trademarks, as long as your trademark's alive, you could license it. So you could have a license in trademarks that went on for hundreds of years. It would be benefiting your great grandchildren, as long as there was some company who liked using your trademark enough. Yeah. So it's different with every type of law. Trade secrets, the same thing. You can license it. You just have to make sure there's plenty of control so the trade secret doesn't get away from you, because then it's hard to license if everybody has figured out the trade secret.
Right.
So there's lots of, you can license about anything. It's just being creative and figuring out what helps you, what helps them. I mean, for example, I had one recently where we licensed technology to somebody, but then they wanted a right if they sold their company that they could convert that license into an assignment, right? Because the technology, that it was so valuable to their company that they were licensing, it would make up a substantial part of the value of the company if somebody acquired them. And so they had to make sure that they would maintain those rights. And so they basically said, look, we'll give you a lump sum. If anyone acquires us, we'll give you a large lump sum at that point to buy out your rights.
Okay.
So
are there certain protections that need to be built into a license to prevent misuse or loss of rights? Especially if it's a good idea, I could see some bad actors trying to, I don't know, do some bad stuff with it.
Yes. Yeah. And this is why it's important to, talk with your attorney and look at things. One of the issues in if you license technology is what's happening to the technology in the future. So if I license you my camera patents on your phone, what's going to happen next? And so many licenses will have a clause that any inventions that you make that stem from the licensed technology, the ownership goes back to the original owner. So the licensee or licensor, right? So that way they don't basically take over control of the technology where your license becomes worthless without their technology, because then the value goes down. So many will have a clause that comes back to you. When you're licensing trademarks, you need to make sure that you're checking on the quality of the product, because a trademark, the idea behind trademarks is that you know what you're getting, right? So when you go to McDonald's, you know what you're getting. It's not a gourmet burger, but it's not going to put you in the hospital either.
Yeah, most likely it's going to taste the same every time you
exactly.
go. Yeah.
So you know what you're getting, and that's kind of the point of trademarks, is so the public knows what they're getting. They know the quality they're getting. Well, if you license your trademark and then don't pay attention, and the quality falls through the floor, then you're really deceiving the public, because they thought it was going to be quality A and now it's quality B. And so when you license a trademark, you have a duty to basically verify that quality is maintained. Now, often that is done with just a pro forma statement that says we will have periodic quality control checks to ensure that happens. Often those don't happen. But it's a good idea too, because you want to make sure that if you ever get those rights back, if the company goes out of business and you're going to license somebody else, you want to make sure that your mark hasn't been tarnished. If you're Tiffany's, right, you don't want really cheap knockoff jewelry being sold under your name.
Right.
And so there's provisions in trademark law to do that. If you're licensing trade secrets, obviously, there's very strict language usually about who can access the trade secret information. What steps the company has to do. For example, if I license you my trade secret on something, I'm probably going to require that every person in your company that comes in contact with that information has to sign a non-disclosure agreement that has penalties if they disclose it. You have to maintain the information in a secure facility. So, the rank and file of your company don't see it laying out on your desk. So you put in, depending on the type of IP, you put in restrictions that prevent the value of your IP going down. Another one is if you're an author of a book or a line of books, say, for example, you may have provisions when you license your work, right? So J.K. Rowling probably had provisions when she licensed the rights to Harry Potter that limited what the studios could do.
Right.
They can't put pornography in the book. Or in the, I mean, because a kid's book, it's just not going to be the same if you show up and there's a bunch of gratuitous sex scenes in it.
Right. Yeah. Or violent murders or something like that. Yeah.
Yeah. It may work in Wayne's World. It doesn't work in Harry Potter. But so there's, you put provisions like that in, so you make sure you're not damaging the brand
Right.
while you're using it. And that's really important, and depending on what you want to use it for. So,
yeah, no, that makes a lot of sense. That's important for sure. You got to protect that reputation. All right. Well, thanks for listening to today's episode of Infringe at Your Own Risk. If you're ready to monetize your patents, trademarks, or any of your intellectual property the right way, visit batemanip.com to connect with Rand and the team. Of course, don't forget to subscribe to our channel. Leave us a review. We very much appreciate it. Rand, great seeing you again. Thanks so much for all the insight.
Thanks for having me.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.